So we are now on chapter 6, or the performance or consummation stage of the contract of sale. So in the performance stage, guys, this is the part wherein the parties are supposed to perform their respective obligations. So on the part of the seller, his obligation is to deliver possession and transfer ownership, while the buyer must pay the price. It is only the complete performance by the seller and the buyer which will consummate the contract of sale. So the seller, in addition to delivering the property and transferring ownership, has other obligations. First, to preserve. So prior to the delivery of the subject matter, the seller must take care of the thing sold with the diligence of a good father of the family, in accordance with Article 1163. Okay, and by default, the expenses incidental to putting the goods into a deliverable state must be borne by the seller. Okay, this arises from his obligation to preserve the subject matter before delivery. Okay, so the seller is also obligated to deliver the fruits and accessories, and the amount or extent of the fruits and accessories is reckoned from the time of perfection until final delivery. Okay, but there is an exception, which is the res perit domino rule, which we'll discuss later. So the seller is also obliged to warrant the thing in accordance with Article 1495. And the seller, general rule, must pay for the expenses for the execution and registration of the sale, as well as the obligation to pay the capital gains tax. So what is delivery? Delivery is also known as tradition. So it is a composite act in which both parties must join and the minds of both parties concur. It is an act by which one party parts with the title to and the possession of the property, and the other acquires the right to and possession of the same. Composite act, guys, it means that it consists of several actions or parts or steps. So how is delivery made? Article 1497 states that the thing sold shall be understood as delivered when it is already placed in the control and possession of the vendee. So possession is the best gauge for control. Okay. However, control of the vendee can take other forms other than actual physical possession. So what is controlling, guys, is the control and not necessarily the actual or physical possession, which will tell us whether the legal effect of tradition has already been produced. So there are several kinds of delivery or tradition. There's actual delivery, and then there's constructive delivery. Okay, and there is also what we call the quasi-tradition. And then there's a rule for delivery of negotiable documents of title. And there can also be delivery through carrier. So these rules are all found in the law on sales. So constructive delivery, guys, this is actually just an agreement between the seller and the buyer, that the buyer is understood to have control of the subject matter of the sale upon the performance of some act by the seller short of actual physical delivery of the thing sold. Okay, as long as they agree, oh, imuha na na, maski wala pa gyud kay buyer ang property, then that will pass as constructive delivery. So you already know that the execution of a notarized deed of sale, a public document, is the highest form of constructive delivery. So the notarized deed of sale has two functions. It operates as a formal or symbolic delivery of the property sold, and it also authorizes the buyer to use the document as proof of ownership. So the rule, guys, that has developed due to this Article 1498 is that the execution of a public instrument is equivalent to actual delivery. Okay, but the catch is that the thing sold must be subject to the control of the seller, so that at the moment of sale, its material delivery could have been made. So what if the seller has no right or control over the thing sold? Then of course, mabali ang rule. The execution of the public instrument will not amount to actual delivery. So I already mentioned this in chapter 5, when the execution of a public instrument will not produce effect of delivery. So if there is a contrary stipulation in their deed of sale. Delivery through carrier, guys. The carrier here, or the shipper, acts as an agent of the buyer. Okay, take note, agent of the buyer. So when there is an agreement that the seller will send the goods to the buyer, then the delivery to the carrier is deemed as delivery to the buyer. Okay, general rule. So in this instance, when the seller must send the goods through a carrier, the seller must contract with the carrier under reasonable terms with due regard to the nature of the goods. Okay, if the goods end up getting damaged, the buyer can refuse receipt and hold the seller responsible for damages or return or refund, reimbursement. So the rule on insurance, guys, is that although the seller is obliged to deal with the carrier under reasonable terms, kaning insurance, dili ni siya included sa duty of the seller. So the seller must notify the buyer first if there is a need to procure insurance. Okay? And kung ingon si buyer nga ipa-insure niya or di siya mo ganahan mo kuha insurance, then the rule, as long as notified si buyer, is that the goods shall be deemed at the risk of the buyer during transit. So si buyer na ang ni-assume sa risk. So ma-transfer ni kay buyer ang risk, guys, if the seller will notify that there is a need to insure the goods during transit. Okay, valuable kay siya or fragile siya. So what are the kinds of delivery through carrier? So we have the FAS, or free alongside seller, alongside vessel. Free alongside ship, FAS. So the rule here, kung FAS ang agreement, is that delivery is completed when the seller places the goods alongside the vessel or the ship. So the moment na mabutang ni seller ang goods sa ship, then delivery na siya to the buyer. Diba? Kaya the carrier is the agent of the buyer man. If the agreement is FOB, or free on board, the seller shall bear all expenses until the goods are delivered, either as follows. FOB at point of shipment, then delivery to carrier is deemed delivery to the buyer. FOB at point of destination. The delivery is only considered as complete when the vessel arrives at the point of destination. So if something happens to the thing prior to this point of shipment or point of destination, then si seller ang mo bear sa risk and mo bear sa expenses. So FOB at point of shipment, mura lang siya pareha sa free alongside vessel. Okay? Pareha siya sa FAS. A third agreement will be CIF, kaning cost, insurance, freight. And the rule here is na two schools of thought. So two schools of thought sa kaning CIF agreement. Na ay school of thought that CIF borne by the buyer and it is part of the purchase price that he obligated himself to pay, such that delivery to the carrier is already delivery to the buyer. However, there's a second school of thought that CIF, when borne by the seller as part of the package price na iyahang offer to the buyer and was accepted by the buyer. So the delivery by the seller of the goods to the carrier is not equivalent to delivery to the buyer. And the seller continues to bear the risk of loss during the shipment period. Right, so place of delivery, guys. General rule is that the buyer must get the goods at the seller's business place or residence. Okay, and exceptions lang kay if there's an agreement to the contrary. Usage of trade dictates otherwise. And in the sale of specific goods, which parties knew to be in some other place, then that is the place of delivery. So whether it is for the buyer to take possession of the goods or for the seller to send them depends on the contract between the parties. Time of delivery. Where the seller is bound to send the goods, but no time for sending is fixed, then the seller must send it within reasonable time. And what constitutes reasonable time is determined by the circumstances of the particular transaction, as held in the case of Smith, Bell and Company versus Mati. So what circumstances? So the character of the goods, the purpose for which they are intended, the ability of the seller to produce the goods if they are yet to be manufactured, the available transport facilities, and the distance, and the usual course of business in that particular trade. So reasonable time will be measured in accordance with these circumstances. So what happens if the goods are in the possession or is being held by a third party? How can the delivery be made in this situation? So the third party here who has in his possession the goods must acknowledge to the buyer that he holds the goods on the buyer's behalf. Right? If that third party will not make this acknowledgement, then the seller is deemed to have not fulfilled the obligation to deliver. So how do we know that delivery has been completed or there is complete delivery of the thing sold? So there are different rules, guys, provided in the civil code. It depends if the property is personal or real. So for personal property, there are two rules found in Article 1522 and Article 1481. And with regards to real property, the rules are found in Articles 1539 to 1543. So in the sale of movables in mass, and there is variance with respect to the delivery. What makes it, from where does the variance arise? So if the goods delivered are less than what was contracted, or if the goods delivered are more than what was contracted, or when the goods delivered are mixed with goods of a different description. So in these variances, guys, what are the remedies of the buyer? So kung less than ang gi-deliver than what was stipulated in the contract, then the buyer can reject all of those things delivered, or the buyer can accept with knowledge that seller cannot deliver the rest and only pay at the contract rate. So kung per piece ilang agreement sa pagbayad, then only the number of pieces actually delivered will be paid by the buyer. Or accept without knowledge and pay only fair market value. So knowledge, guys, this refers to the knowledge of the buyer na kung si seller maka-deliver pa ba sa deficit. Kung nasa knowledge that dili na maka-deliver si seller, then to be fair to the buyer, then the buyer will just pay at the contract rate. But if wala knowledge si buyer, pag-accept niya dili na tayo maka-deliver sa deficit si seller, then liable only to pay for the fair market value. In the second situation, guys, when there's too many items na gi-deliver, it is more than what was contracted. So the buyer here can accept the contracted goods and reject the rest, or accept all of the delivery and pay at contract rate. Okay, the only instance when the buyer can reject is if the subject matter or the thing sold is indivisible. Okay, so bayad jud si buyer. Sobra-sobra gud nang gi-deliver sa iya gud. Unfair gani ni sa seller. In the third situation, when goods are mixed with those of different description, so the buyer can accept the goods and reject the rest, itong different description. And ma-reject pa siya only if the subject matter is indivisible. So in sale by description and sample, or sale by description or sample, there are rules provided by the Civil Code. So what is a sale by sample? So there is a sale by sample when a small quantity is exhibited as a specimen of the bulk of the goods which are not present. Okay, and there is no opportunity to inspect. And there is sale by description when things are sold as being of a particular kind, and the buyer does not know here whether the seller's representations are true or false, okay, but relies on them as true. So if there is sale by description or sale by sample, the rule is that the seller must deliver the bulk of the goods which corresponds to the sample exhibited or to the description made. And in sale by sample and description, so na sample, nag-describe pag yun, nagpalami pag yun storya si seller, then the bulk of goods delivered must correspond with the description made or the sample. Okay? Not, dili na siya or guys, and na siya. How about immovables? The completeness of the delivery, guys, of the real property depends on the pricing agreement of the parties. So there is an agreement on pricing, which we call as the unit price contract. And there is another kind, which we call the lump sum contract. So kung unit price contract gani siya, then we take a look at articles 1539 and 1540. And in lump sum contract, that's in article 1542. Unit price, meaning 1,000 per square meter. Lump sum contract, it's 1 million for 1,000 square meters. So lump sum daan. So what happens, guys, if upon delivery, by more than or less than the area na sabutan sa parties ang naaragyo dito. So in this case, guys, when the immovables are sold per unit or number, we use article 1539 when what was delivered is less than what was agreed upon. So the rule in 1539 is that the vendor must deliver all that may have been stated in the contract. And if that's not possible, the buyer has the option to choose between proportional reduction of the price or rescission of the contract. But take note that rescission can only be made when the lack in the area is not less than 1/10 of that stated. So meaning, double negative man ni siya. The deficit must be more than 1/10 of that stated in the contract. So the same rule, guys, same remedies if the immovable is not of the quality specified in the contract. Okay, but ultimately, guys, if the deficit here is to such extent that had the buyer not known, if the buyer had known of this deficit or lesser area or its inferior quality, the buyer would not have entered into the contract of sale at all. Then that is the instance when the buyer can rescind the sale, regardless of the panang 1/10 na rule. Okay? On the other hand, Article 1540 provides for the rule when what was delivered is greater than what was agreed upon. So the vendee here can accept the area included in the contract and reject the rest. But if the buyer will accept the entire area delivered, then the buyer is obliged to pay for the same at the contract rate. So the buyer must pay, for example, 1,000 pesos per square meter of the excess area, kung unit price contract. So sayon ra guys ang rules sa unit price contract. But what happens if the contract is for lump sum? So different rule provided in the Civil Code. There shall be no increase or decrease of the price, although there be a greater or lesser area or number than that stated in the contract. So bound si seller by the lump sum na stipulated in the contract. Even if mas dako yung na-deliver na area. Yeah, bound sad si buyer even if lesser ang na-deliver sa iyaha. There cannot be any proportional reduction even if lesser ang area. Yeah, that is the same rule we apply when two or more immovables are sold for a single price. Okay, but with respect to this rule, guys, if the agreement specifies an area or number, the vendor shall be bound to deliver all that is included within the boundaries of that lot, even when it exceeds the area or number specified in the contract. So if that is not possible, then the seller shall suffer a reduction in the price in proportion to what is lacking in the area or number. Okay, and unless the contract is rescinded because the vendee does not accede to the failure to deliver what has been stipulated. So, nani exception, guys, ang Article 1542, and that's found in Roble versus Arbasa. In this case, guys, land comprising of 240 square meters, more or less, was sold for lump sum. Okay, but the area turned out to have 644 square meters. So, kadako, diferensya is the excess area included in the sale. So the rule here, guys, is that no, as decided by the Supreme Court. Why no man? Diba ang rule man kay there shall be no increase or decrease in the price. So significant kay ni ang kanang phrase nga more or less with respect to the identification of the subject matter of the contract of sale of real property. So a vendee of land, when sold in gross or with the description more or less with reference to its area, does not thereby ipso facto take all risk of quantity in the land. The use of more or less or similar words in designating quantity covers only a reasonable excess or deficiency. If dako kayo ang excess or dako kayo ang deficit, then di na to automatic na i-apply ang 1542. Okay? It is unjust, right? It will result to unjust enrichment either on the part of the buyer or the seller. So take note, guys, that the actions, katong mga remedies provided in 1539 and 1542, it prescribes in 6 months counted from the day of delivery. So na may bagong palit yuta, wala ninyo gipa-survey before ninyo gibayaran, ipa-survey dayon. Ha? Okay, 6 months man ang prescription ani. So there is also delivery in installments or by installments. So 1583 states that unless otherwise agreed, the buyer of goods is not bound to accept delivery by installments. Okay, so general rule, the buyer cannot be compelled na mag-installment delivery si seller. Right, and when there is a contract of sale of goods to be delivered by stated installments, which are to be separately paid for, meaning buwag-buwag sa dang pagbayad per delivery, and the seller makes defective deliveries in respect of one or more installments, or when the buyer neglects or refuses without just cause to take delivery or pay for one or more installments. So it depends, guys, on the case-to-case siya nga basis, and it depends on the terms and conditions of their contract. Whether there has been breach of contract that is so material as to justify the injured party in refusing to proceed further and suing for damages for breach of the entire contract, or whether the breach is severable, giving rise to a claim for compensation but not a right to treat the whole contract as broken. So in this case, guys, mahog na murag na agreement ang parties, contract of sale, but na ay mga mini contracts under that contract of sale. Why do we call it mini contracts? Okay, na may separate deliveries and separate payments per delivery. So when there is non-performance of the obligations by either parties, then 1583 provides the rule on how we'll identify whether the breach is so material as to justify the refusal to proceed further with the contract, or only a claim for compensation but not to rescind the contract entirely. So when is the seller not bound to deliver the thing sold to the buyer? So 1524, of course, kung wala pa nagbayad si buyer. If the vendee has not paid the price, or if no period for payment has been fixed. Another instance is when the vendee loses the right to make use of the term as provided in Article 1198. And in Article 1198, the vendor shall lose the right, the debtor, not the vendor. The debtor here, or the buyer, shall lose every right to make use of the period. So in the following circumstances, so basahan ninyo, review man ni sa oblicon. Kung na-insolvent na si buyer, unless na siya gihatag na guarantee or security, if no guarantee or security has been furnished to the creditor, when the debtor by his own act has impaired the guarantee or security after their establishment, or when the debtor violates any undertaking in consideration of which the creditor granted the period. Okay, so effect of delivery is that the ownership of the thing sold is transferred to the vendee. And the ownership of the thing sold is acquired by the vendee from the moment it is delivered to him or her in any of the ways specified in Articles 1497 to 1501, or in any other manner signifying an agreement that the possession is transferred from the vendor to the vendee. Right? So general rule, delivery will transfer ownership except when there is no valid sale, when the seller is not the owner, when there is express reservation of ownership, when it is implied in the form of the bill of lading, and in sales on approval, trial, or satisfaction. So why are these exceptions to the general rule? Of course, kaning express reservation, klaro nang kayo ni reservation man. So mga contracts to sell. So the reservation can be until buyer has fully paid the price or until certain conditions are fulfilled. So that's express reservation, but there can be implied reservation too. So when are there implied reservations? So ingon sa Article 1503, if the bill of lading, kailan man yung bill of lading, guys, no? Kanang mura siya proof nga it's a document that will be issued by the shipper when goods are being sent by the seller to the buyer, the transport siya, or when it is being held by a third party. So there is implied reservation, guys, when the bill of lading is deliverable to the seller or to the agent of the seller or upon his order. Right? And there is also implied reservation when the bill of lading is kept in the possession of the seller, even though it says there na deliverable na siya to the order of the buyer or to the buyer. And another implied reservation is when the buyer does not honor the bill of exchange and wrongfully retains the bill of lading. So kanimo kung bill of lading, mo rin siya nag-evidence na ugpungan. It's a symbol of the thing sold. Nga naa siya naka-deposit ba ron sa warehouse or ship siya somewhere. So it symbolizes the goods or things sold. So kung naay ingani na situations, then we can surmise that there is implied reservation of ownership. Okay, so remember this, contract to sell. It's a bilateral contract whereby prospective seller, while expressly reserving the ownership despite its delivery to the prospective buyer, commits to sell the property exclusively upon full payment of the purchase price. So just a review sa atong previous discussion. Okay, remedies guys. Kung contract of sale, it will be specific performance and rescission. However, in a contract to sell, there is extrajudicial rescission by the seller because the failure to pay the purchase price in full is a positive suspensive condition. Okay, and the failure of which is not a breach, but it will just prevent the obligation of the prospective vendor to convey title from having binding force. Okay, and review na sad, contract to sell versus conditional sale. Remember guys na the rule on double sales will not apply to a contract to sell. And the property may still be alienated or mortgaged by the owner before the fulfillment of the condition in a contract to sell. Okay, siya man gihapon na ang owner. Unlike a conditional sale, na void na siya. Because the seller is no longer the owner. What happens to the contract to sell when the parties subsequently execute a deed of absolute sale? So in the case of spouses Lumbres versus spouses Tablada, the court ruled here that the execution of the deed of absolute sale effectively rendered the previous contract to sell ineffective and canceled. Okay? Even if wala sila ikon. Even if the deed of sale is silent or will not refer to the previous contract to sell, deemed ineffective and canceled na si contract to sell. Okay, the whole point of the contract to sell, di ba, is for the seller to eventually execute a deed of sale. So the execution of the deed of sale will render the contract to sell functus officio. How about this? Why is this an exception to the rule that delivery transfers ownership? In a sale on approval, trial, satisfaction, or acceptance, in this case, guys, there is delivery to the buyer on approval, on trial, or on satisfaction, or other similar terms. However, despite this delivery, the ownership will only pass to the buyer. First, when the buyer signifies approval or acceptance to the seller or does any other act adopting the transaction. Or even if wala ni signify si buyer of his approval or acceptance, but the buyer retains the goods without giving notice of rejection. And if a time is fixed for the return of the goods on the expiration of such time, or if no time has been fixed, then at the expiration of a reasonable time. And what is reasonable time is always a question of fact. So that's why, guys, it's considered as an exception because certain facts or acts need to happen before there is transmission of ownership. And there is a special sale called the sale on return or return contracts. So this is a sale subject to a resolutory condition. And this is different from the sale on trial or on approval, or on acceptance, because here the ownership passes to the buyer upon delivery, but the buyer may revest ownership to the seller by returning the goods instead of paying the price. But the goods must be returned within the time fixed by their agreement, or if there's no time fixed, within reasonable time. So that concludes our discussion on chapter 6. Okay, I'll upload another video for chapter 7 or double sales. Is this already chapter 7, guys? Let me check. Okay, but I'll just upload another video for a discussion on double sales.